The Dan Yorke State of Mind program is brought to you in part by Lookout Rhode Island and Takeo Comfort Solutions.
Good evening and welcome to my State of Mind. I am Dan Yorke. The fitness clubs that wouldn't close, that were forced to by the courts, our continuing conversation tonight. This evening, we'll talk with the lawyer for the club who makes a pretty good argument about the constitutional problems and the arbitrary decision that he thinks, the club thinks, the governor made on all this. Attorney Charles Calenda will be my guest. Let me remind you about the case once again with the report from 12 News last week.
The governor said shut it down, and today they did.
I think it's frustrating.
It's kind of a bummer.
Maxx Fitness refused to shut its doors, claiming nothing they do is a threat to the public.
How could all the studies show that health and exercise help in a fight against COVID, yet we're in a health pandemic and you want to shut down fitness centers?
But the Rhode Island Department of Health begged to differ. In a hearing Friday, the DOH says hospitals are full and the health system is crashing. And if Maxx Fitness stayed open, they were afraid other businesses would rebel too.
We make choices. We can make choices to stay inside. We can make choices to go and to other people's businesses. And
I feel like the gym isn't really any different than other businesses that are allowed to stay open.
When the clock struck 9, these gym doors closed for the next 10 days.
Kind of worried that they're going to go out of business.
And people being cooped up inside, that can really mess with their head, and getting to the gym, you can really get that out.
Gym goers think there are other options.
Maybe lower the capacity a little bit. Make sure everyone's being socially distanced.
Maybe like making appointments to come in so that they know how many people are going to be in at a time. Maybe decreasing the amount of people allowed in each area at a time.
The hope is that on December 14th, they can reopen for business, but they aren't holding their breath.
I could be proven to be a prophet.
And so we're joined by the attorney for Maxx Fitness Clubzz with the two locations in Warren and Lincoln. He is attorney Charles Calenda, representing Matt D'Amico, who is fighting for his business life here amidst this pandemic. Counselor, thank you very much for joining me. Appreciate it.
Thank you for having me on, Dan.
This is the second night in a row that we've talked about this. Last night we talked with Blake Filippi, the state minority leader in the House of Representatives. And, he's also an attorney, and he offered all sorts of discussion about the General Assembly's role here and whether it could actually preempt the agita that your client feels. Ironically, well, maybe not ironically, coincidentally or appropriately, you made that part of your discussion with the judge during the temporary restraining order process last week. I'll get to that in a second. Why don't you give me, not unlike I thought it was a high-level performance for you at the court at the TRO hearing, give me your best executive summary on this. And then we'll dig into some of the details.
Sure. So basically, the summary of how this came to be is essentially the governor had issued her latest executive order on November 30th, scaling back a lot of businesses, particularly when it comes to fitness centers and gyms, which obviously Maxx Fitness Center is a fitness center and a gym. They closed those entirely. My client is the entity that owns that gym. As you mentioned, Matt D'Amico is one of the principal agents of that business. They were faced with the position of either complying with the shutdown order or pause, as the governor has called it, or continuing to stay in business, because obviously just because their business can't operate doesn't mean their expenses go away. Their everyday business expenses I'm referring to, and their expenses that they need to run the business. So they had to be faced with that, basically that very difficult choice. They chose to stay open. The Department of Health sent inspectors to view their business being open and issued them an immediate shutdown order pursuant to their normal process, an immediate compliance order, I should say. That would be what the Department of Health would do. Despite that order, the business remained in operation, and the state of Rhode Island, through its Department of Health, filed in the Superior Court a complaint for injunctive relief and declaratory relief and an emergency motion for a temporary restraining order, which is what was heard on Friday before Judge Long in the Superior Court.
Right, perfect summary. Appreciate that. I actually just finished. You're watching the show, folks, Tuesday night. My deadline for my column on the Valley Breeze is Tuesday morning, and I started by saying the state took a shot. Should it have blown up, it could effectively end the pause and render Governor Raimondo and some of her authority weakened for sure, perhaps useless. I think the weight of the state is significant in the process, and it's an uphill battle for you. Certainly it was with the temporary restraining order. You're going to have a chance now to argue this case at length on December 14th, the day after the pause ends. I don't think anybody believes the pause is going to end on December 14th with the spiking numbers. So I think you're still in play. Talk to me about that, and then I want to get into some of the arguments. There's kind of two sections of your argument. The move by the state, they simply could have continued to issue fines and let the fines total up for your client at $500 a pop. And at some juncture, he would, the virus goes away and he's got, $25,000 worth of fines, and then he hires you to go in and try to mitigate the fines and see if there's some compassion somewhere while he continued to operate.
Yes.
So I think the state recognized that they could have done that, and for the most part, it seemed like everybody else was complying. So that may have eroded over time, but the state decided to get in early, take the crapshoot, see if they could have the judge shut them down, and effectively, end this thing, and they were successful. Do you think the state is acting in a high-risk fashion, even though they won the TRO?
Well, they certainly accelerated the process, and it would have required, under normal circumstances, my client going through administrative appeals within the Department of Health if they wanted to appeal the immediate compliance order, the fines. It would have taken several layers of administrative appeals to get to the Superior Court, where then it would have been my client's burden to bring the action in the Superior Court to overturn what the Department of Health had done. So there is some risk for the state, and I think it was an issue that was not addressed by Judge Long in the temporary restraining hearing, but it was one that was addressed by me, and that was the fact that the state was seeking to enforce the emergency regulations being promulgated by the Department of Health under General Laws 4235, 23.10, and the timeframes that the governor has attempted to suspend in that particular statute so that they could continue in perpetuity. And that really is the linchpin of what the state was arguing, because if that regulation is found to be invalid or expired, and the governor did not have the authority to continue to suspend the time limits within that, they could not use the statute that Judge Long cited to enforce that in the Superior Court, and the state's case crumbles.
Getcha. Now, listen, when the viewers are listening to code and legal citations, it gets a little bit heady, but you gave me an opportunity to pause here. When we come back, we're going to break down a little bit more simply the two arguments that are in place here by the defendant. One, that, this authority is out of control.
Right.
And two, the actual decision is arbitrary, unfair, and capricious. We'll talk about that when we come back with attorney Charles Calenda, representing Maxx Fitness Clubzz in Warren and Lincoln, and their ongoing battle here with the state over the pause. Be right back. Welcome back to My State of Mind. Attorney Charles Calenda, goes by Chaz. He is the counsel for Maxx Fitness Clubzz in Lincoln and Warren. The owner there very publicly disputes the closing of his business. His customers were getting their sweat on for most of the week last week until Friday, when a temporary restraining order was issued by Judge Melissa Long, arguing or deciding for the state, as the state argued their case. Your defense against the governor and this TRO in the longer hearing that will take place on Monday the 14th is fascinating. It'll duplicate what you argued in the TRO, but in more detail and with witnesses, and that, I think, is going to be interesting. Break it down for me again in as simple layman terms as you can, Chaz, that the there's two arguments here. A, the governor is over her skis, that this emergency authorization has gone on too long. And in fact, she actually took the law, if you will, that the General Assembly offered her for authority, and then used her own executive authority inside that permission to extend the authority past its deadline.
Yes.
That's case one. That's argument one. And the argument is, hey, it's not fair. You know, physical therapy joints are open. You know, the restaurants are at 33%. What are you doing to me? I mean, so that the practical argument we'll grab in a second. Isolate that authority argument. Do you think under any scrutiny at all, you can get the judge to do what the legislative branch has, you and I agree on this, fallen down on?
I certainly hope so. I think that a fair reading of the statute that gives the Department of Health the authority to issue emergency regulations outside their normal authority, and the governor's authority to declare an emergency and act within the powers the General Assembly gave her, they're clashing here with normal traditional separation of powers issues. So the governor has very specific authority under the statutes that the General Assembly gave to her. As I mentioned in my hearing on the other day, that the governor has basically exceeded those powers by going above and beyond what the statute lays out what she can do. Now, the Department of Health, in coordination with the governor's office, has issued emergency regulations. They're called Safe Activities for Covered Entities. That's basically what the regulation is called, which has been in place since May 5th of this year. And that's the regulation that requires all the safety precautions that the gyms and every other restaurant and business have been to abide by since it's been in place. That statute only allows a maximum of 180 days for those emergency regulations to be in place. So we're past that 180 days. The governor, through her executive authority under the emergency statute, has said, you know what, that statute, the time frame is getting in my way, in the Department of Health's way, of regulating what I think are appropriate actions. So I'm going to suspend that time frame under the emergency authority that the General Assembly has given me. So this regulation, the Safe Acts by Covered Entities, continues in perpetuity as long as the Department of Health continues to reauthorize it.
Here's the thing. If you're able to win on that, look, let's not kid ourselves. When this case came in front of Judge Long, she was well prepared on your briefs. I mean, she turned around a lengthy discussion right after the oral arguments. That she was pretty much prepared. Look, let's not kid ourselves. The weight of the state and all those machinations that you talk about, which I think make perfect sense, may not make the day anyway when she takes a look at the practicality of what will be perceived. And that is, a judge stepped in and let the gyms operate, which would be a wildfire top story across the country. And no one is going to pay attention to your articulate arguments about constitutional and executive authority. You're just going to be like, holy cow, a judge let the clubs open. And she leans on the health department's right and the governor's right to just say, look, we're the responsible party to keep you safe. We think we should do this. You're arguing then on the we think we should do this, the second tier, which is all the constitutional arguments aside, restaurants are open at 33%. I can go in and get my Achilles taken care of at physical therapy, which I did this week. We were 14 feet apart on treadmills. Where's your evidence that the gyms are really causing problems? And by the way, your client just came up, sent to me last night, this study in Europe that says that gyms aren't super spreaders. So, yes. Right?
That's exactly right. There are many studies that have said gyms I think worldwide accounted for maybe 400 cases, at least in that European study that they were talking about. And there's been nothing that the Department of Health has pointed to, especially in Rhode Island, that has said gyms have been these super spreaders or highly dangerous situations where all these cases are coming from. I think it was something like 75% of our fatalities and serious cases are coming out of nursing homes, not gyms, not restaurants, not these, not everyday small businesses. So, Judge Long apparently thought that the study that the state cited from South Korea, she had to give a tremendous amount of credence to that, but there's no evidence the state has looked at anything else while making their determinations to determine whether or not that study is credible or should be balanced against the other studies that are out there.
Well, look, I mean, it was her own articulation. I'm paraphrasing here, but more or less, she talked about it being common sense in her mind. Listen, they sweat a lot. There's heavy breathing and there's a lot of sweat, so we're shutting them down. And to the naked ear, that might sound okay. That seems safe, but I don't know. I just don't know that in this very data-driven crisis that we are in, that gut checks will carry the day, in court.
I would hope not, because I've been a trial lawyer for almost 15 years now, and you can't go on gut feelings and maybes and possibilities. You have to have evidence. You have to have data, and that's all I'm asking for in this particular situation. I want there to be somebody come out here and show me some data. What's the meaningful difference between you going and having your Achilles tendon worked on in close proximity with a physical therapist, and people who are socially distancing, wearing masks in a clean, regularly clean place, environmentally controlled as far as the humidity and temperature, which is one of the things that Dr. Scott cited in her affidavit as being making gyms more potentially dangerous. What is the meaningful difference here? Or are we just making decisions based upon gut feelings here? That can't, as a person who wants to see the law followed, who wants to see data, who wants to see evidence, that can't be what carries the day.
When we come back, some might say, well, didn't she say she was going to pay these clubs while they were down? We'll talk about that and a couple other interesting aspects of this case with Attorney Calenda for the Maxx Fitness Clubzz, who continue to say we should be open. We'll be right back. With the counselor for Maxx Fitness Clubzz, Attorney Charles Calenda. This is the club that made a lot of news last week and ended up in court with the state trying to remain open during the pause. Look, the governor has a grant program for businesses during the pause. Now, I have been on record on both platforms on radio and TV talking about the incompetence of the governor's efforts to actually fund this business community. If they get the formula straight, it may be that the club actually gets tens of thousands of dollars to remain open or to remain closed in this situation. What is your read on that particular case? Because early on, they had that program so screwed up, the most he was going to get was $500. They are still reviewing the protocols, within the protocols of the grants. Why not apply for the money and take his hits?
Well, I'm sure that he probably will apply for the money, but the people I've spoken to who have already applied based on their reduced capacity to, take in business are telling them that the state hasn't even responded to their applications because of, the way the state government works, unfortunately. So, my client estimates that he'd receive perhaps $4,000 to $10,000 while this quote unquote pause is taking place. But when you look at the business expenses that are his everyday business expenses, I'm not saying $4,000 to $10,000 is not a lot of money, but it is certainly not going to keep him available to reopen his business for any great length of time.
It puts his business in. He may get up to 50,000. I don't know what his pro forma looks like. Your meter is running on this whole thing. This is just the stress for business owners in this particular case. I will tell you, I give this guy. Some might say he's irresponsible. I don't find him to be irresponsible. I think he seems like a serious guy who has a serious case and who, frankly, is sticking his neck out and representing a lot of businesses, via this case. Because if you are successful, the pause cookie crumbles. We're still fighting a virus, so we don't want to start, spiking the ball in the end zone over something like that. But there's a lot at stake, and this is a serious investment that he is making. You gotta laugh with me though for a second. The irony. It's only in Rhode Island, and timing is everything. Today, Judge Melissa Long, who's overseeing this case, was nominated to the Supreme Court. She's the top contender in the list. Of course, she's being, nominated by the plaintiff in this particular case, the governor. Only those who are wildly cynical would suggest that she wouldn't decide against the person who is appointing her to the Supreme Court. I'm sure that's not a concern for you, correct?
It's not a concern. I know she was officially nominated today, and I congratulate her for her nominations. That's quite an accomplishment for her.
All right. And by the way, I did not realize while you were arguing the case, and I'd never been in touch with your work, and I was listening, I'm thinking, man, this attorney is pretty sharp. This is no fly-by-night work here. I find out that you're a potential candidate for Attorney General. Is that a serious discussion you're having right now?
Yes, I've actually declared my candidacy. I declared it in late September. I've been campaigning as best I can in this environment that we're in. But I am a Republican nominee, not Republican candidate for the office of Attorney General. And I'll tell you, it's on similar issues, not this one particularly, but similar issues of state actors not following the law or selectively following the law that really got me into this, particularly the issue that Peter Noronha, the current Attorney General, refused to go to federal court to defend state law on the mail-in ballot issues that eliminated the notary and witness requirements. He was nowhere to be found when there was a validly and duly issued state law that was trying to be eliminated, and in fact was eliminated for this election in federal court.
Well, sorry we missed your announcement, but clearly, if your work in this case so far is any indication of your credibility, the general, who's in a pretty good political position, I think, is going to have a little battle on his hands. So good luck with that. We'll have plenty of time to cover your candidacy, that's for sure, a couple of years.
Thanks, Dan.
But in the meantime, good luck on the case, and we'll see you after the 14th.
Oh, well, thank you very much for having me on, Dan.
All right, we'll continue to follow this. And a final word when we come back. Stay with us. The case of the Clubzz versus Rhode Island is not over, and we will follow it on both the radio and right here on My State of Mind as it proceeds. Don't forget, weekdays 3 till 6 on the radio on WPRO, and back here tomorrow night. Thanks.